Good evening, everyone. My name is Tom Lambert. I am the Chair of Fairfield Fair Rent Commission. Fairfield. I want to first call our meeting to order before we get to our substantive meeting business. So I'm going to go through and take a roll. I myself am present. James Casey. Present. Doug Jones. Here. I don't see Carl. Is Carl on? No. Okay. Dr. Ibrahim.
Here.
Eileen.
Here.
And no Maureen, I guess, right? Okay. Maybe we should talk offline about that. But we do have a quorum. So I think the first agenda item that we have is to hear, consider, and approve the meeting minutes from our July 8th special meeting. Do I have anyone willing to put that up?
So move.
Do I have a second?
Second.
All in favor?
Hi.
Aye. All opposed? Hearing none, the meeting minutes are approved. That brings us to our main attraction for this evening. Agenda item number 4. It's case number 2404, Casella v. Bozzuto Management Company, otherwise I think known as the Anchorage. So what I'd like to do first is just get introductions from who is present, before kind of going into a little bit of an explainer of how I'd like to have this go. And when I say how I'd like to have this go, this is only our second foray into this. So you guys are still a little bit of a game thing. This is Eileen's first. So, but let's start with you.
I'm Dawn Viola. My mom is Dolores Casella, who lives in 213.
Yeah.
I'm Robin Richardge, also Dolores' daughter.
Got it. And is Dolores gonna be joining us? Okay.
Rick Rizio, I'm an attorney and one of the owners of the Anchorage.
Yeah, thank you. And do you have anybody else from the Anchorage? Okay. So everybody who's planning on being present is present, in other words, correct? Okay. So the way that we did this last time, which isn't to say this is the best way to do this or the right way to do this, just the way that we've done it before. I'm going to ask that each party, starting with you folks, you decide who's going to speak or who's not. We'll give a short sort of opening statement. And the opening statement is just a sort of verbal, sort of very quick, doesn't have to be long in detail, summary of why we are here, what your complaint is about, what you would like to see done, and what you can expect the commission to hear in your evidence. Council will be able to then go to represent the landlord's position. And then we'll go into our evidentiary portion, which is testimony or other documentary evidence that you have. You can testify in terms of a narrative or question and answer, whichever, however you want to do this. But you and any witnesses can speak. You can refer us to any sort of documents that you have, anything that we should be looking at as we make our decision, anything you'd like to draw our attention to specifically, so we make sure that our eyes are properly focused on what's important. And following your presentation of the evidence, you will be subject to cross-examination from the other side if they so choose. After your case is over, so to speak, we'll get to the landlord's case. You will get an opportunity to ask questions of the landlord after the landlord gives their presentation of evidence. And at the end, we'll have summaries, closing arguments, so to speak, where you guys can summarize not only, again, what we should be looking at and focusing specifically, but what we heard here today too, and what your response might be to some of the things that you heard. I do want to emphasize this is a question and answer sort of available opportunity. So you can ask questions of the other side, just like they can ask questions of you. And we're here to get to the truth of the matter, whatever that is. So we have very loose evidentiary sort of rules. This isn't court or anything like that. I'm a lawyer, counsel here as a lawyer. Nobody else here is a lawyer, though. And we're not bound by any sort of rules of evidence. So we have a lot of latitude as to looking at what you want us to consider. hearsay, you might hear that as a sort of term of art in the legal sphere. We're not worried about that. It all goes into the weight of the evidence that we have to consider. And after you guys are done with your arguments, your closing, so to speak, we will all deliberate and we'll may come to a decision right here as to how we think this should turn out. The deliberation period is just for the commission members to talk amongst ourselves, although you of course can be present to witness. And we are hopeful that we can come to a decision that is going to make everybody equally happy or equally unhappy, or will be in favor of one party or the other, but it's bound by the ordinance that we have to be bound by, that we're charged by. That's it kind of in a nutshell. And don't worry if you didn't remember all that. I will try my best as a chair to guide us along the process. First things first, and I don't think we did this last time, but we should do it this time because I looked at the charge again. We need to swear anybody who's going to be testifying. So if you will be testifying, you just need you to raise your right hand right now. You swear to tell the truth, the whole truth, and nothing but the truth on penalty of perjury. Okay, good. And with that, we can begin. So, who's going to start our opening? Would it be you? Okay. Whenever you're ready.
To the committee, and on behalf of my mom, Dolores Casella, who resides at the Anchorage here in Fairfield, and my sister Robin, we would like to thank you for your time and consideration. We're here to present a difficult situation for our mom and to ask that as a committee, you can review the facts we present from the perspective of Dolores, who is 86 years old, living on a fixed income, receiving state assistance through SNAP and QMB. When Dolores visited the Anchorage, she expressed her appreciation for the opportunity to possibly return to Fairfield as a resident after she had moved from her home on Lally Boulevard and later to a rental that was devastated by Sandy. After hearing the rental information, she thanked the person who had given her the tour of Anchorage and stated that she would not be able to afford the rental and was very sad to not be able to live there. When she was asked to give the administration a few days and then was called to meet and review a proposal that included affordable housing provisions that not only addressed her year one there, but incorporated an agreement for as long as she continued to pay her rent there. We, as her daughters, agreed that she could leave the secured affordable housing where she resided in another town that had clear and secure guidelines for a cap on her rent for the length of the time that she would live there. Over the past 3 years, Dolores has participated in the Anchorage social events and has enjoyed the opportunity to be a part of the community. My sister Robin will highlight the changes that have been made from that first lease to date, and we ask that you consider if this is fair and equitable for Dolores. And I'll conclude with some closing statements when we're done. Thank you.
So I was with my mom, initially.
Well, first, I just want to say, so is this going to be part of your testimony as to?
I don't know where this fits in.
Okay, yeah, so, well,
So maybe that's
Basic.
the opening statement. So I don't know if she clarified exactly what we're looking for and you had asked.
why
that.
don't you tell us that?
Okay,
Yes,
I'm-
exactly.
Right, okay. So what we're asking is pretty straightforward. The Bizzuto Association, and I want to try to just say that I'm not sure if Bizzuto and Anchorage is one and the same, or if it's two separate organizations, and you mentioned it was Bizzuto. So when I'm referring to Bizzuto, I guess I'm referring to the Anchorage and Bizzuto. I just want to clarify that because I'm not really sure how I should be addressing.
You can describe as the landlord and.
Okay,
and
great,
Whoever
great.
the rent is owed to.
Okay, so what we're asking for is for the landlord to stand by what they offered my mom initially in order for her to make an informed decision to live there, which was to have a fixed rent starting at $1,110 a month, fixed for 3 years, and that from the 4th year and onward to have a cap of no more than 1% increase on that rent for the length of the time that she would live there. That's what we're asking for, nothing more, nothing less, just stand by what it was that your organization offered my mom wholeheartedly.
Your review.
Okay, so I am one of the owners, and also the attorney. Bizzuto is not an owner. We don't really have authority to make those kind of arrangements. We never even found out about it until after the lease of the first year. We are very strongly adhere to all the affordable housing regulations. Mark will tell you, we go through every rent with him before we sign a lease. We found out this lease, I don't know how this appeared in a 2021 lease. It was never approved by the ownership. And every future lease, we made sure that it was not in that lease, which has been signed by the tenant. However, we thought out of fairness was that we would increase it. We held her rent and we agreed then to increase the rent this year by only 1%. So I really don't know why we're here. However, we have basically stated that in the future, we're going to, whatever the rent that is charged pursuant to our affordable housing area is what is the rent that we're going to look to collect. It would not be fair to all the other people. I don't know how this got in here. We had a line of 100 people that wanted to get into these units. There was no reason for us from a market standpoint that we had to fix any rent, agree to any rent. We didn't do it with any other tenant. It's not fair to the other tenants who are in the building. The rent, to give you, I think I submitted the rent is, she right now is being charged is probably 20%, 20 to 30% below what the affordable rent is. And it's about a third. So she's paying $1,100, I think it's $1,500 for a comparable unit. The market rate on those rents is $3,800. And we made sure that after the first lease, that this provision was not in any future leases, but in a show of good faith, we held our rent through what was an unauthorized representation. We didn't even sign a lease, Mizuho signed a lease. They have no authority. They're not the management. They're the management company. The person who actually signed the lease has left, and we don't even know how to get in touch with them. So I don't know how accurate all the statements are. I can't refute them. And I can't say they're true or they're false, but all I can tell you is we found out about it. All future, there were 2 subsequent leases that were signed without those clauses in because we wouldn't have signed those leases. And then as a show of good faith, we kept it and we offered a 1% increase this year with a note in there that any future rents are going to be set pursuant through the affordable housing committee so that it's similar to every other rent that's charged, affordable rent that's charged within the building, which I said is about a third of what the market rate is. So this is about as fair a rent as anyone can charge. I don't know how anybody could argue that the increase is not fair. It's 1%. And we're just not going to sign another lease that's going to say that it's going to be fixed for 1% forever. Why, first of all, I don't understand why we would have ever agreed to it. Or everybody knows how your taxes, your insurance, your water, everything goes up every year by a lot more than 1%. We've done what we think is the right thing, which is even though we were not obligated to under the lease for 2022 and the lease for 2023, we continue to hold the rent there. We increased it by only an offer of 1% this year. And in the future, we are just going to, whatever the similar situated rents approved by the Affordable Housing Commission or affordable through Mark's office, the calculations, that's the rent we're going to charge, which is similar to all. But that's next year and in the future. So I don't understand how a fair rent complaint has given when there's I don't understand how anybody could find that a 1% increase this year is unfair. And it's 30% of what the town tells you is the affordable, which is 1/3 of the market rate.
Sorry. So we'll get a chance to explore that, I think, more.
I could point out, you have the leases, they were loaded up. I supplied all the leases. You'll notice it's not in the 2022, it's not in the 2023 leases. Both leases were signed by the tenant and they were signed by the management company. And the 2024 lease, which shows that there's only a 1% increase and that there is a clause in there that says in the future, rents will be as established by the affordable guidelines set forth by the town of Fairfield.
All right, so thank you for those kind of open.
And I hope you've all seen, I think I submitted an exhibit that showed you what the rents were for the affordable units and what the market rate rents were.
Anyone needs to see any of the exhibits, I'm happy to share those at appropriate time.
And have you guys had a chance to review what was uploaded?
We should.
Okay. So why don't we start with your guys' case, so to speak? Testimony, documents, whatever you guys have. have. Everybody's here to be heard, okay? And just, I caution you, though, that if council wants, because he's a party too, he can ask a
So
question.
can I do some questions first?
Well, you can ask questions of him when it's his turn to
Not
testify,
about what
so to
was just
speak.
presented.
Well, you will be, you know,
Okay.
you'll get an
All
opportunity
of those.
later on. Yep.
Thank you.
So since I was there the day when we came to see the property, the Anchorage was a new property. We, my mom had heard about that they had the affordable apartments. And she asked to go and see them. I took her there to see them with caution. Janice Miner, who was a vice president of Bozzuto at the time, met us there. I guess maybe because it was a new, organ, a new community, she was doing, not sure why she was there herself doing the tours, but she was. And she greeted us. She showed us an apartment. My mom, of course, fell in love with it. She said, oh my gosh, I would just love to live here. This is beautiful. I'm not sure if I'll be able to afford it. We talked to Janice about what was affordable for my mom. We explained to her my mom's situation, which was that she was living in a rent-controlled community, but not in Fairfield. And she would just love to come back to Fairfield, but she was very concerned, will I be able to afford this? We talked about what was affordable. Janice wholeheartedly said, you know what, let me just sit for a day and let me get back to you. And she promised within a few days that she would get back to me. She did personally get back to me. And when she got back to me, she asked me to consider an offer that was made to my mom. It wasn't anything that my mom asked for. She didn't ask for any considerations. She just said, I don't think I can afford this. Well, what can you afford? Oh, okay, well, this is what I can afford. And she came back and she said, here's what we can offer you. And she was very clear, it was very straightforward, and it was exactly what I mentioned earlier as to what we're asking the landlord to stand by. When she offered it, I remember saying to her, are you sure that this is okay with the owner? Are you sure that this is going to stand by? If you're not here, since this is a long-term commitment and we're intending for my mom to continue living here as long as she's able to, she's not looking to jump around to different places. And, are you sure that this is going to be able to be fulfilled honestly and that we won't have any issues down the road? And she assured me that all the notes would be, in the file, and that whether she was there or not, there would not be any issues whatsoever. We talked about putting, she talked about that she would put the clause in the lease. She did put the clause in the lease. It read to be exactly what she had offered. And my mom said, oh my gosh, I am over the top flabbergasted. Please, can I move there? And we said, based on what we see in this lease, yes, because they are committing to this with integrity. And so we offered to move her. And through the second and the third lease, although my mom didn't notice that the clause had been taken out, she would have no reason to notice that, because I believe that the rule is that you should, if you're going to change a lease for an ongoing tenant, it's fair practice to let them know that you're changing the terms of the lease. She hadn't received anything saying that they were changing the terms of the lease. And in fact, they weren't changing the terms of the lease and they were standing by it. They were abiding by what they had said that they were going to do. So my mom had no reason, nor did we, to anticipate that there would be any change in what they agreed upon and what they put in the initial special provisions, which outlined the first 3 years fixed and then fourth year forward 1% max. So we were just kind of going along according to plan and had no concerns or any inclination that there was a concern on anybody's part. So I just need to be clear that the intent was set, and to council's point, to the landlord's point, I don't know who signed your lease, but somebody who represented your company sign the lease, put the provision in there. You guys made the offer, somebody from your organization, whether it be Bozzuto or the Anchorage, but somebody who represented you, put that provision in the lease, verbally offered it. My mom accepted, they wrote it in the lease, and then somebody signed it. And it says right in the lease, you're legally bound by this document. And the wording then says, from year 4 onward, not to exceed 1% per year. So since that was what was written in there and somebody signed it, I don't understand how you couldn't have known or not know who signed it. That doesn't make sense to me. Somebody signed the lease.
And maybe you can direct your comments to the commission.
Sure.
Unless you have questions for Attorney Rizzo
sure, I'm
after.
sorry.
No worries, just
Yeah.
when you look, you can
To everybody.
stare me down. you know.
Okay, I don't mean to. do that. I'm just.
I understand.
So I know that the Anchorage has a rider that is an affordable income apartment. That part we're I guess all in agreement with. And I guess what we feel is that regardless of what, when the Anchorage or the landlord put together their protocol of how they would proceed with rental and with rental amounts, I imagine that they would have had some kind of a blueprint when they opened up the doors to how they were going to proceed with the rents and what they were going to charge. So the fact that they offered this to my mom, if it's out of character with what they're asking other people to pay for rent, is not really part of the issue or the argument, because it's not relevant to what we're asking them to stand behind. I can't speak to how they got to what they're charging other people in the fair housing and the guidelines. I can only say, this is what was offered to my mom. And that's what we were focused on. We weren't paying attention to what anybody else was going to be paying. I don't know when those rents were established or how, and I don't feel like it's relevant to what our complaint is.
The other point is the rider to the lease agreement for affordable income apartments that is in every lease my mom received specifies that the Fairfield Planning and Zoning Board, based in part on the condition that a landlord is required by law to strictly enforce these restrictions. It talks about utility allowance. My understanding is that for the affordable housing, the cap that's there, that's been referred to as my mom being 20 or greater percent less than others, is supposed to include what she pays for her utilities as well as what she's charged for rent. My mom is paying her own utilities in addition to the rent that she has in her lease. So that needs to be included. It's not, this is what she's paying and that's 20% or 30% too low. You need to add back in, this is what she's paying in addition, this is what her utilities are. And in addition, there's a $600 a year required fee of the Anchorage that everybody pays. So that's also added into the mix. So it's not quite as clear cut as one might think when you say, oh my gosh, a 1% cap would do that. That's not really something that's on us. What we're all about here is we set up this individual to be living here with an agreement, and the agreement, not only is there a 1% right now, but that's not where we didn't get to that 1% easily. That 1% didn't start out in year 4. Year 4 started out with the conversation that we are going to get to the maximum allowable for your mom. And we are going to start with, you talk about the 20% less, we're going to throw in that 20% year 4, 21%. That's what started our concern. Then it was turned around by the Anchorage to say, okay, we'll go with the 1% for this year. Well, here we are. Okay, what happens after this year? You're clearly saying your intention is to bring her up to where everybody else is supposed to be for the maximum you can get out of that apartment for affordable housing. We're here to say what's fair and equitable for Dolores. When you've made this agreement, now you want to change this agreement. And not only do you want to do that, but you want to get the most that you can out of that affordable housing unit. And let's not talk about what's fair to other people who are paying less. We didn't ask for this situation. And she made an informed decision to move out of a secure setting that she can't get back into. You're well aware as a community how difficult it is for individuals to find affordable housing. And there was not a list of 100 people waiting for those apartments when we came to see the Anchorage. We were invited to be a part of the community as an affordable housing unit. They needed to get those units filled. We didn't ask for it. It was offered. And based on that offer and that legal document that was signed, we as her daughters who are feeling quite upset about the stability for our mom said, okay, fine, we'll move you out of what's very stable because it's what will make you happy. It's where you want to be. And now the rug has been pulled out from under. So let's not talk about it as it's only 1%. Why are we here? Your intent is to go far beyond the 1% in as quick a time as you can. There's no stipulation as to a security that we can have for her as to how are you going to do that? You know, what's going to be the increments that you're going to do that? Is it going to be, you know, a 50% increase to get you to the cap? Or is it going to be 20% a year? I mean, we have no idea. And that is unfair and not equitable for Dolores Casella. And we're really feeling like we hear that you didn't know, that's on you. You didn't know. That's your organization. It's not fair to penalize a resident of Fairfield who's living in one of your community settings, who followed the rules and who accepted an offer and who has a legal first initial lease that is guaranteeing her stability. That's on you if you didn't know that's what happened. That's not on Dolores. We didn't make it up. We didn't propose it. We didn't ask for it. So I don't know how you're going to deal with that, but it can't be creating a hardship for a senior citizen who's living in your community, who came here because she wanted to be part of your Fairfield.
I guess I'll just add to that, that it's important to consider the potential impact of the tenant who is, you know, in that affordable housing, to ensure that you have to be compliant with fair housing, but where's the humanity in this situation, and looking at the human side of things to take a look at that. And it's not so much about rules, it's you on your honor made an offer and now you're going back on your word because you feel like you can.
Anything else you would-
I don't know.
First of all, it's 100%
Well,
untrue.
do you have questions for?
No, because no one was there.
I understand, but I just wanted, before procedure, do you have questions for either of them?
No.
Okay, so you can testify, and present whatever evidence you want, knowing that, again, you're going to be subject to the same cross-examination. Okay,
No problem.
all right, so, you know, before we start interrupting each other or anything like that, just like you let you present your evidence, we're gonna let him say what he wants. You can ask him questions afterwards,
Sure.
if you wish. It's up to you whether you want to or not. Then we'll get to summaries at the end where you can respond to what he's gonna say. But that's just how I'd like to keep it procedural. So
First of all, it's absolutely untrue that we need to recruit people for the affordable units. And I can probably check with Mark and see that the desirability of these affordable units. We had, as one of the owners, when we even made application to the zoning board, I can't tell you, 25 calls. People, can I get in there? Can I get in there? Put your name on the list. We did not need to recruit anybody to come into this building for these rents. So there was an unauthorized, we knew nothing about this. And it's interesting that they said, well, you signed the lease, or whoever's responsible signed the lease. Now you have to live up to it. Well, the same, I would think, would go for them for the next 2-year leases, which were signed without those provisions. They signed them. So if I have the responsibility for somebody who signed an offer, we would have never authorized it. We didn't need to. We weren't sure of our responsibilities. We believe we're we've tried to put teachers, we've tried to put policemen, we've tried to put local employees in there so that they can live in affordable units and stay in the units. And it's about, as I said, almost a third of what the market rate rents. When we found out that the clause was in there, the next two leases, I don't know if they were told, I wasn't a party to it. We just said those clauses not to appear in those two leases. Those clauses appeared in the leases were signed. We were told they were signed and people understood that those clauses weren't in there. The leases are signed, just the way they said my lease was signed. And who's ever signed it is responsible for it. So the old lease is gone. There's a current lease of 2022 that has expired. There's a lease of 2023 that has expired. Both those leases did not have those clauses in. I was told that we were instructed to say, do not put those in those leases, and we were told that people understood. Now, here's the other. So then I made it clear when there was some rumblings, I said, look, I don't want to have any misunderstanding of this. I want to put in the lease next year that the people understand that they would pay the affordable rent as prescribed by the town. And so we gave her, still in a show of good faith, fixed her rent for 3 years when we didn't need to. The two leases that they signed did not have a clause that required that. And then gave a 1% increase only this year. My understanding here is we're talking the whole relevance of this meeting today is whether, and you can, I'm asking you as chairman, is whether the increase that we're put in the lease is fair. Now, everybody has said 1% is fair. That's what the increase is this year. And that's it. And which I believe is not only fair, it's more than fair, below market. Costs have gone up 4 to 5, 6%. The town itself with affordable, the increase in affordables has gone from, in these units, from I think 1303 to 1550. And that's the town's description of what is a fair and what is an affordable rent pursuant to their guidelines. So we've done everything we're supposed to do. We've notified them, they've signed for some reason, I'm responsible for signing a lease that was unauthorized, but they claim they don't have any responsibility for signing leases in the future that do not have these clauses. You can't have it both ways. So I wanted to make it clear this year, because I didn't want to have any misunderstandings. We agreed to only a 1% increase when the rent should be about over $1,500. We've agreed to only increase it to $1,122. But with the understanding that we're not obligating ourselves forever and ever. The person did not have the authority to do it. We have had no knowledge of this until the increases came out. And we said, well, that's fine. You can, because whoever made that deal, who's left the company, will honor that for the 3 years. And then the first year we'll give the 1% increase, but that's it. And we have 2 leases that support the fact that those restrictions aren't in there. And now we've offered a 3rd lease to just say, you know, this is what we're obligated to do legally. This is what we want to do. We're not trying to be unreasonable to people. That we had no, and I can tell you, they did not need to be recruited to come into that building. I had at least 25 to 30 calls directly to myself that I referred over to them for people to come in for affordable units. People were dying to get into the building because the rents were so low for the quality of the building that they're living. I'm not trying to be hard-hearted, but this was not, I don't know how this got in there. And I'm furious that it got in there because there was no reason that clause should be there. And it's not in any other lease in the bill. Other people have asked us in affordable units, can't you do anything about our, you know, can you make our, I said, look, this is not fair. And we were told by the town, everybody should be treated fairly across the board. I don't know how this happened. We've rectified it, I believe, in the 2022 lease, in the 2023 lease. Both signed by your mother, just as I had a responsibility to look at it, which I never saw it, but we lived by it. 2 leases down, now there's a 3rd lease. I just don't want any misunderstandings going forward. But I don't think, it's my understanding, the whole purpose of today is to decide whether a 1% increase is reasonable under these terms. That's what the committee, and that's what's been offered.
Anything else?
What's that?
Any questions?
Yes. First of all, the purpose of our complaint is not about the 1% in question.
Yeah, so
Oh,
you
question.
can, so
Okay.
when we
Okay,
close at the end,
Fine.
You can respond, but if you have questions for the witness, not for us, but for the witness, then you can ask those now.
So you stated that someone told you that we were told, my mom was told that there's been a mistake and it was not supposed to be.
We were
in
in,
there.
we,
Who was that
I
person
don't-
who
I
told
don't
you
know.
that?
I don't know, we were
Employee?
instructed by Basuto, we told them to make sure that that clause did not appear in future leases. They did it, and they said it was taken care of. That
So
was
it was verbally communicated to you, but there was nothing that was presented to you to ensure that my mom was clear, because there was nothing written in year 2 or year 3.
If-
It wasn't in there, but there was nothing written to tell her, this is no longer going to be the way you signed it on the first lease. We can no longer honor this guideline, this proposal, this lease. It was never given to my mom in writing, so you took a verbal from someone
Yes,
who
it's right.
said, Dolores knows that we can't honor this anymore, and there's going to be an increase.
Make sure you
in
just
year
phrase this as a
4.
question. If you're responding, we can save that for the end, but just make sure you're asking.
That's what I'm asking.
The lease
So-
was told, we instructed Basuto in both those, in any future leases, that that clause was not to be included in any future
I
lease.
got that.
That's it.
How was my mom made aware of it? You said we were told
He was
that
supposed to
she
read the lease.
understood it.
No, I said she. we
No,
were
I
told-
just quoted you. We were told that she
We
understood.
were told, we told them to indicate that that would not be in any future leases. It was not in any future leases. It was my understanding that that was explained.
It was
If wasn't, well, but you also had the obligation to read both leases, just like I had an obligation to read the first lease, which I did not do and never had privy to it.
I'm
And I-
having a hard time understanding how that could not be a part of a responsibility.
Let's just keep this. to
So-
questions.
Questions.
Mhm. So when you talk about the rent that's in your building for other units that are the same square footage, are those tenants paying their own utilities?
Everybody's paying the same thing, yes.
Their own
Uniform,
utility?
Yes,
Utilities not included.
all utilities, utilities are being paid. It's my understanding, utilities are being paid everybody the same.
I don't understand the answer.
That's exactly what I said. The utilities are being paid by everybody the same. It's
And what is the same?
my understanding they pay, there's certain parts, they pay their own utilities. They don't pay for water, I believe. We pay for all the hot water. And then they pay for the balance of the utility.
Okay, so therefore their rent that you're referring to as the fair housing cap is not including utilities.
Our fair housing rent that we charge is the one that's promulgated by the town. And our leases and our affordable housing requirements have all been approved by the town, and that's the way we proceed.
So when we talk about the cap that you have to adhere to for fair housing, you need to then net out what each individual apartment is paying for their utilities, correct?
I don't,
Okay, that is correct.
So I just have a question about something that you said. So were you aware of the communication between myself and the Basuto representatives that manage the Anchorage building regarding this 2024
Yes.
rent amount? So then are you aware, I'll assume, but I'll ask the question since it's posed in that way. Are you aware that in the beginning, we received a letter in April of this year stating that you are increasing my mom's rent to, I believe it's $1,331. And that you would not be honoring the 1%. And that I had a conversation with the representative, Jane, who is at the Anchorage, and had a conversation with her about that. And that, were you aware that following that conversation, Jane said, oh, we've decided now to honor the 1%. And then, are you aware that she then afterwards came back to me and said, oh, no, we changed our mind. The owner didn't know about this and now he doesn't want to do it. So now we're back to raising the rent. And then it wasn't until, are you aware that it wasn't until we actually put a formal complaint in that the 1% was offered to be adhered to? Are you aware of the up and down and the all around about
No,
how
I'm-
this transpired?
Let me answer the question.
Yeah.
My understanding was pursuant to the lease, we issued a new lease that had the new rent. There was an issue that Pizzuto then met with someone from the family, and they were upset, and they just said, well, we offered them to just have a 1% increase for this year, so that would take care of that. And we said, fine, but that's it, not after this year. And in good faith, we will honor the 1%, and that's what I know.
So
But
you
there
didn't
was
know
no
about that in
obligation.
between step that happened where she came back and said, oh no, we changed our mind.
I don't know what she said.
Yeah.
No. I will tell you, no, there won't be another lease that's signed in the building that I would say.
Were you aware that the initial lease special provision had the word onward in it? And that word onward would imply to the tenant that onward would mean from year 4 onwards, would imply that this was something that would continue from year 4 onward.
There was no impression that it was in that lease, it was unauthorized, it was never approved. I don't know how it got in there and how anybody managed to put that in there, because it's not any other lease. And there was never any recruiting of affordable units. We had a list that could go on forever of people begging to come into the unit. So there would be no reason, I don't know how he managed or how Ms. Minor managed to put this clause in there. It was unauthorized. We found out about it, put an end to it, and they had all the subsequent leases signed without.
When did you find out?
After the first lease, and then we said.
So year 2 and 3, there was no conversation on behalf of Anchorage Pizzuto with Dolores Casella.
My understanding that it was clear. It was in the lease. I would assume you read the lease. You asked me
There was
about if I
no
read the lease. Did you read the lease?
There was no conversation with Dolores
No.
Casella.
No need to converse. It was in writing or not in, it was deleted from the lease and asked to sign a new lease.
I get it. So we make a mistake. We don't need to say we made a mistake. We just take the mistake out
No, we made
and
a
then we
mistake.
just assume she's gonna catch that.
Let's
No.
keep it
Is
by
that what you're saying?
Not
Is
catch
that,
it. No, no different than them making a mistake and putting the lease in the future. You asked us to be, there was a mistake that was made in the lease, an unauthorized offer. We didn't read the lease, my fault, okay? All future leases, whoever's signing those leases should read them, okay? Whether you read them or not, I don't know. Whether somebody told you, I know they were told to say, this is to be clear, that this is not, these new leases are what's gonna be in there. You had leases in 2022, 2023 without these clauses. And the dispute came when we wanted to raise, and which we thought we had completely had the authority to do, to raise it pursuant to the town's number. And then we decided, and maybe that was a mistake. Maybe we should have just stuck with the 1330, then agreeing to casually say, you know what, we'll give her the 1% this year, but I want it now expressly clear in the lease that that going forward, we will be looking for the rent that is prescribed by the town under the affordable housing regulations.
what's the 21% increase that came in the letter in April?
That's what the town prescribes.
Was that increase submitted to the town fair housing and was that approved by Fairfield Town?
We use the numbers that are provided by Mr. Parker.
To be clear, the town does not set those rates. Those are promulgated by the Department of Housing and Urban Development for the Bridgeport area. We provide that information to all the landlords to know what the maximum rents are. They're free to charge what they can up to that maximum amount, which does include, it's a gross amount. So any utilities that the tenant's responsible for, they're part of housing costs, need to be netted out. So we don't make any further ownership of those. Those are promulgated by the federal government through the state of Connecticut.
So then,
Any other questions for citizens? Questions, responses, you can save for next.
I guess just one, would you agree that actions would suggest intent stronger than if there was no written communication about a change in the lease for 2022 or 2023, that since you were going along with the original plan and abiding by that plan, that would suggest an intent to
No,
continue?
not at
Thank you.
So now we can close. This is the opportunity, now that you've all heard the information come in through you guys testifying, through your questions, for you to respond, for you to summarize, again, what your position is, especially in light of what you've heard, to maybe respond to what you heard, and to tell us, once and for all, why the commission should make a certain decision or not. So we'll start with you guys.
Well, in addition to the financial hardship, we believe Dolores is facing based on the situation that's been described to us as not having known and now needing to rectify and make changes in your lease. Without Dolores being given the opportunity in year 2 or 3 to clearly understand this is where it was going, to then have Dolores only know about this in year 4 when it was happening, with a letter that clearly showed an intent to bring this rent up rapidly to meet where others are supposed to be. I really feel like it's important for the committee to include the emotional duress and the anxiety and uncertainty that Dolores is feeling when she hasn't had, the ample opportunity over the year 2 and 3 to get ready for how am I going to cope with this? I'm here in this community. This is not going to last. They've decided they don't want to and can't honor this. Here we are now in year 4, and I really feel that it's very important that we understand there's been a clear communication of intent on behalf of the landlord through letter and also dialogue we've just heard, that there is going to be a plan that's going to be quite an impact on Dolores that will impact her ability to continue to live in her apartment and impact her to cope with the way things have changed from 2021 to 2024 with regards to available housing and what's available for her. So coping with it now is quite different than coping with it in 2022 at the end of her first year. I feel like she was not given the opportunity to have someone be absolutely sure that she understood we're not going to honor this going forward. What I feel like happened was we're just going to let it sit for 2 years and then we're going to just change it. And while I understand that we have to read and understand clearly before we sign something, it's a legal document, so too is that year 1 a legal document. And it was written in such a way that really had an implication on decisions that Dolores made that are now going to be very detrimental for her when in fact year 5 comes and the Bozzuto organization Anchorage is going to look to move her that 20, 30, even 50% more of her rent to get to her where that cap is for your Fairfield number for fair housing. So that's what is not fair and equitable. What's not fair and equitable is it wasn't her fault what happened. She was at the effect of it, and now she's having to deal with the detrimental consequence of the landlords wanting to recoup where they feel they're supposed to be with that apartment. And that is going to have severe implications for Dolores. She is an individual who's 86, living with the natural kinds of cognitive problem-solving challenges, memory problems that come with all of us when we get to certain ages. It isn't that she's having any kind of a disability that we need to acknowledge. She is who she is. She's an 86-year-old individual living alone on state support for food, for SNAP and QMB. So she already qualifies for that kind of level of support. So how do you take an individual who qualifies for that level of support, have it be fair and equitable to raise her 20, 30, 50% of her rent?
First of all, it's my understanding here of the increase in the rent this year.
No.
And excuse me. We're here about a 1% increase this year in rent. That's what this fair, in my understanding, this board does is decides if the increases are fit. We sent out a note that brought it to what we are able to do. They told them that they did not agree to that. And we just, as maybe this is no good deed goes unpunished. We agreed to then just have this year be 1%. Now, in fact, even though you signed 2 leases that didn't have these clauses in, very direct, very written. You know, you've got a year to prepare, and then look, this is, the rent is as minimal as can be for this town. We have now given them notice. We thought they had verbal notice, or certainly, as I'm obligated to read the lease, they were obligated to read the leases. Lease 1 is no longer in effect, it's terminated, it's extinct. Lease 2 does not have any requirement, anything except, and that has expired. There was nothing in there about any 1% going forward for the rest of for on and forever. And there was year 3, lease was signed, both parties were responsible for reading the leases, both parties, I assume, read the leases, and no one made mention. Year 4, we went to then put in the effective lease, the effective rent. We were told that how unfair it was, and basically what you've heard today, and we said, okay, we'll honor the 1% this year. We'll have the ability to if they come up to what is still a third of market rate, or move elsewhere. And we haven't, the rent hasn't been set for next year, so I don't know how we're arguing about what next year is yet. All that's on the table and all that's been offered is a 1% increase from last year's rent to this year's rent. And then just an instructional notice that we are not, because if it for some reason hasn't been clear, even though they've supposedly read 2 leases that did not have any kind of, cap requirements in them. We made sure that it was in this lease, so there'd be no misunderstanding. Okay, so I think the 1% increase this year is fair. I can't imagine that they would say that it's not fair. We will not agree to set rents going forward. We haven't done that for anybody. We will not do that for anybody. And if we have to come back here next year and the rent they're offered, they don't like, they assume they have the right to make a complaint to you. But right, as it stands right now, I don't know how anyone can say a 1% increase is not fair. We are not putting forth a rent for next year. And then when we get to the end of next year, we'll send out our notices with what the rent will be. And if they think the increase is unfair, I guess we'll be back here. But I don't understand really how anybody can say that the 1% increase this year is unfair. And I don't think that this commission has the authority to dictate the terms of our lease going forward. We haven't set forth any rental terms. They'll be given a renewal notice next year, 60 days or whatever it is, 90 days before their lease. And then who knows what rent the state or the city, the state will say is the affordable, should be the affordable. And this, maybe this is a no good deed goes unpunished. We're the understanding that those 2 leases, it was clear that these caps would not be effective. We made sure we put it in a 3rd lease and then still honored only a 1% increase this year. I don't know what more we can do, but we're not going to agree to a 1% increase for forever. It's that talk about not being fair. That's not right. And it's absolutely 100% not true. I've been with this project since day 1. I've been owner of this project. We built this project. I've been on that site every day. And we had the affordable units were a laundry list. We even had a waiting list for the market rate units. The whole building leased within 30 days of units going on, not even 30 days. Every time we put a unit on, the units would lease within a week. I don't think we've never had a unit sit there for less than 30 days vacant. There was no reason for us to recruit. I don't know what Ms. Miner was thinking about. I don't know what kind of deal these people made. But it was one that was never authorized by the ownership. And it's one over year 2, year 3. We made sure it was not in the lease. And then we even made sure that it was in writing in the offer in year 4. However, keep in mind, the only increase this year in rent is 1%. That's it.
Okay,
May I just clarify one thing? It's really important to me.
what's the one thing?
The complaint is not about 1% increase this year. I feel like there's a miscommunication. The complaint is about reneging on the offer that was made in the initial lease in 2021 that said it would be fixed for 3 years, and from the 4th year there forward, it would only increase on a cap of 1%. we are not complaining about the fact that the rent has increased 1% this year. That would be within keeping of what they agreed to. What we are trying to complain, the concern is, and concerned about is that it has been implied clearly in writing to us that the intent is to raise the rent up this year to the maximum ability that they can, and that they are not planning to continue on as they have abided by for the last 3 years, which would show intent to abide by it moving forward, that they are choosing not to, and that we have to anticipate what will happen in 10 months. So if we're going to be back here in 10 months and wait this out and just assume that, okay, they did say it would just be 1% for this year, that's true. That is the end of what the agreement that what they offered us in the end for this year. But that's not the point. The point is the original lease, the provisional clause that was offered and accepted and signed by their organization, and how they abided by that and what the intent is moving forward. Thank you for letting me clarify.
Of course,
I can respond to that.
I don't have people to. So thank you for your presentation of evidence. I really do appreciate it. It's for us, I think, at this point to deliberate, but I do want to add, since we haven't said anything about where we're at right now, because you asked for a clarification. The Fair Rent Commission is here to determine whether a rental increase is harsh and unconscionable. And we only have before us the lease to determine whether that increase is harsh or unconscionable. The lease, as I see it, is a lease for 2024, that's for $1,122 per month. Is that correct? That's it, right? I don't have a lease in front of me that is for anything beyond. So I can't prejudge what is going to happen in the future. I can only, I think our commission is only charged. And my fellow commissioners can tell me if I'm wrong, but the way I review our charge here, I think we can only review whether a complaint about a rent increase being harsh or unconscionable is subject to a lease that is before us. And the lease that's before us is for a 1% increase for 2024 into 2025 as it was before. I don't interpret our charges allowing us to set any other terms to a lease or to dictate the terms of the lease going forward. And if there is an increase in the future, if there is an increase that is harsh or unconscionable, we may at that point in time then decide that's not fair, that we need to do something about it. But right now, the lease that we have before us is for a 1% rent increase. And that's, I think, what we are bound or limited to. I don't know if there's any other commissioners that have one of these.
Mr. Chairman, that was my first question to you, actually. And I tend to agree with what you said now. I think our charge here is to look at what's written in front of us, which is the lease for this upcoming year. I don't think it's our charge, at least today, to look at what's beyond the next year. And I think I will agree with that.
Any other commissioners want to weigh in?
There are elements here that I find kind of problematic, although I think that Cher's reading is probably correct. However, there's the 2021 lease. These leases are what, 18 pages long, like something like that?
It's about 60. 60 with addendums.
Well, they're lengthy. And you're talking a woman in the mid-80s who I don't know, I see Dolores sort of saying, okay, well, they're accepting my checks. And I think that when council says well, it's in there in writing, well, it's not in there. It, and that was a deliberate choice that somebody made. I think it's a bit disingenuous to telling you what's going on in my brain, okay? And, her checks apparently were accepted and so forth, and, I'm a senior citizen myself. And, I don't know, I feel it's disingenuous to use that, but I think we're probably hamstrung.
I have to tell you a few things. Number one, this is a difficult case. I have to admit, it has too many dimensions. Some of the dimensions are emotional, personal, that I fully understand, are significant. But I also think that that's not necessarily part of our charge. Our charge is to look at the merits. That's number one. Number two, some legal clarification, maybe it's for you, Mr. Chairman. If I sign a lease in 21 that has some clause, and then the same two parties sign a lease in the following 2 years, assuming that party read what they're signing, this assumption, will that legally, that's a legal question, you are the only attorney, will the new lease automatically invalidate the previous one?
I think that that is a very good question for the superior courts of the state of Connecticut to interpret, which I think is outside of our
Right.
charge. It's not to say that one party is right here or wrong here. I think that the nature of the complaint, as I understand it, about what was represented, what was included in the lease, what happened subsequently, what will happen in the future, might be more of a subject matter for our housing courts or our superior courts, but just not for our fair rent commission. So I can't answer that if what the effect of a subsequent lease is on a previous lease in these circumstances specifically. But I think that there are avenues for those disputes to be adjudicated that are in the hands of a court that has that authority beyond ours.
My next question will be maybe for Mark and Mr. Rizzo. Understand that this unit is classified as affordable in that property, correct? Is the list of units you provided, this is all considered affordable? So units 115, 116, 118.
Yeah.
So there's a list of all the affordable
Yes.
units and what their rents are up top, and then there's the market rate below.
So all the units on top are affordable.
Correct, and 215 is 213.
13 is what we're talking about. The question to Mark, right now with hard numbers, town of Fairfield, Connecticut, what is the limit for one bedroom?
Off the top of my head, it's in that vicinity.
It's about 1,600,
Seventeen.
1,700.
Did I say 1757?
That's the sheet that you
Yeah.
said, 1757 is what.
That would be 1,700 something minus the
1757,
utilities you are
but that is
responsible.
Not including utilities.
That is a gross.
Minus the utilities you are
Yeah,
responsible for. Okay.
So that very well could be compliant based on utilities that the tenant is responsible for.
I see. The other question, again, legal question, again, you are the only attorney here, so. I am a landlord and I have similar units in the town of Fairfield very close to the same location. So I will not tell you the number, but I know exactly what's the market there and we know what's affordable there for a one bedroom. I find it very unusual, extremely unusual to have a lease that says it's 1,100 for 3 years. And then beyond forever, it's 1% increase. That's a very good deal, I tell you, extremely good deal for anyone. So my legal question is, can you explain to everyone, again, the legal terminology of unconscionable contract? That's number one. Will this become under this definition? This is unconscionable contract that is voidable?
I can't answer that. I can say that the superior courts in the state of Connecticut can answer that question. My role as the chair, you're gonna get me to answer a legal question one day, but I want to keep our focus here as to what we're able to do. And
I will-
I can't judge what's unconscionable, what's not. I have my opinion as to what happened here.
Mhm.
And I don't want to confuse my interpretation of our charge with being condoning of what was said, representations that were made, the customer service that was going on here, the internal communication or lack thereof going on with the landlord, and any unfairness that might be then, prejudicing the tenant as to what their future might hold. All I'm saying is that the rent that is being charged in the lease that we have before us appears to me to not be harsh and unconscionable. Where that goes in the future, we might be back here and we might be answering that question and saying, yeah, whatever is coming down the pike, is harsh and unconscionable. I don't know. We don't have that lease, so I can't make that.
That's fair to me. I think this concludes the discussion that if we are looking at the lease for next year, consistent with all
So we have to make,
signed leases, and it's very fair, you ask me, beyond fair rent,
so are you making,
beyond, be less than the affordable limits. So
so are you making a motion then to find the rent to be, oh, sorry.
I have a
Yeah.
question. Well, next year, do you plan to bring her rent up to that rent? That would not be fair.
Well,
If he's trying to bring Dolores's rent up from 1,100 to 15, that's like gonna be a $500 increase.
I haven't made any commitments to next year. We don't know what the rents are gonna be, other than what Mark will tell us, and then what's negotiated. That's all.
The only thing is, I know you're dealing with an 85-year-old lady that didn't know what she was signing, so my heart goes out for her. And when I see these rents and she's paying 11, and you're gonna try to get her rent up, I do feel
I
bad.
can tell you, that never would have been offered. I don't know how it was offered. I don't know what was discussed. I can
It
tell you
was
right
offered.
now, we had,
well,
I think we did not need to attract, to give any other rent increases to entice somebody to come into that. I can tell you that with all my heart, because I was there every day.
I think that when you're hearing a preview perhaps of how the commission might weigh this matter in the future, is that fair to say?
Yes,
Okay. Am I hearing a motion to find the rent to be, that is in this lease to be fair and reasonable?
yes,
Okay, do I have a second? I'm gonna actually make sure that I stick with the proper language, so Attorney Pierce doesn't get upset with me.
Well, it's actually, because you're dealing with a tenant that is in a protected class, the standard is a little bit different. It's set forth here, but it does indicate
I want to mirror the language
that should be fair.
and equitable. Yes, sorry. Fair and equitable.
I move that the rent as proposed in the lease for next year is considered fair and equitable.
Okay, do I have a second? All those in favor say aye. Aye. All those opposed? None? So we have our decision. I think the, perhaps how the commission is gonna feel about this in the future, things with that consideration, but I think our business here today is stuff.
See you next year. Thank you.
To adjourn?
Move. Second. Second, Eileen?
yes, I second
All
it.
right, all those in favor?
Aye.
All those opposed? All right, thank you very much, everyone.